If you're a business owner, an academic, artist, or creative in some way, there's a good chance that you may well be the owner of original copyright, which affords you protection against others using or infringing that copyright in certain circumstances. Copyright is governed by the Copyright Act 1968 and is a type of property that provides exclusive legal rights to an owner and protects the rights to copy, publish, communicate, or publicly perform the copyright material. Here is the answer to the 7 most frequently asked questions about copyright in Australia. Number 1. What types of work are covered? This may include engravings, blueprints, TV and radio broadcasts, graphic design, audio recordings, digital files, marketing strategies, business systems, drawings, novels, illustrations, musical scores, maps, and even house plans. The works must be in material form, which can be either hard copy or electronic, in order to be recognised as copyright material. You will have exclusive rights over your artistic work for 70 years from the date of first publication, while a protectionary period of 50 years for radio and television broadcasts, and only 25 years for published editions. Number 2, so what is not covered? Generally speaking, ideas, techniques, or concepts may not be covered where the right is based just on a look or feel of published work, like a newsletter. Number 3, can copyright be owned by more than one person? Possibly, in the example of a set of house plans where the copyright will be owned by the builder, but may also be co-owned by the property owner. However, generally speaking, one person owns the material and they license it to another person for use. This is the case where a software developer creates a product or a graphic designer designs your artwork. They will generally own the copyright unless you specifically address this in your contract with them so that their rights in the material transfer to you on completion and payment. Number 4, can I assign, license, or sell my copyright? Yes, the Copyright Act provides that it can also be dealt with in the same way as personal property. For example, assigned, sold, licensed, left by will, or passed on according to intestacy or bankruptcy laws. If you're giving permission to someone to use your copyright in a certain way, it's important to have an agreement between you that makes each party's rights and obligations very clear so that your ideas aren't stolen or used in a manner that you're not comfortable with. How do I enforce my rights? Where someone infringes your rights and creates something substantially similar, after you have provided them with access to your work, then you should seek an injunction from the court restraining them from reproducing your original work. You may also be able to file damages claims, seeking an account of profits or delivery up of the infringing items, for example, them given back to you. Number 6, how does copyright differ from trademark laws? Firstly, trademarks must be registered where copyright does not need to be registered. However, it is good practice to put the copyright symbol on your work to indicate your copyright in the materials. A trademark is used to distinguish the goods and services from one person to another and may register perhaps a logo, word, letter, sound, picture, number, phrase, smell, shape, or even an aspect of packaging like the purple wrapping for the Cadbury chocolate. Your registered trademark gives you legally enforceable, exclusive rights to use, license, or sell the goods and services that are subject to registration in that class of product or service. And number 7, what about patents? How do they compare to copyright? Well, like trademarks, patents must be registered to be legally enforceable. They are generally a design or invention, and the visual appearance must be new and distinctive.